Welcome to the debate. Today, we're confronting a real tension, I think, at the heart of the modern republic, how the state classifies domestic opposition. We're looking specifically at the use of these specialized terrorism labels for internal groups. Everything from the highly political declaration labeling Antifa a major terrorist organization, to the legal framing of the January 6th events as an insurrection. And this isn't just academic. It dictates who gets surveillance, who gets charged, and ultimately how justice is delivered.
It is absolutely critical. And the central question, the one we really must grapple with, is whether the state's use of these specialized domestic terrorism labels inherently represents, an unacceptable slippery slope erosion of constitutional liberty and due process. Or, on the other hand, are these classifications maybe justifiable tools for signaling and addressing severe, ideologically driven threats that maybe traditional crime codes just fail to capture?
Right. My position is that the use of these labels is fundamentally a direct betrayal of constitutional due process. The label really serves as a political mechanism designed to bypass the protections guaranteed to every citizen, regardless of their ideology. And look, our existing criminal laws, conspiracy, sedition, assault, arson, they are perfectly sufficient to prosecute any and all criminality. We simply don't need a new, authoritarian classification.
But I suppose I'd frame the debate a bit differently. I'd argue that the ideological nature and the coordinated severity of some of these collective actions warrant a unique classification. The threat posed by a widespread, politically motivated movement that's attempting to destabilize governance is, it's fundamentally different from, say, a street gang committing robbery. So even if the current legal meaning of a label is vague, it can still be a necessary political and, yes, investigative tool to communicate and address the systemic danger of these ideologically driven threats.
That's a compelling statement, but let's really look at the mechanics of the danger here. My core thesis is this. The terrorist label functions primarily to strip away fundamental Bill of Rights protections. We're talking the 4th, 5th, and 6th Amendments. It is not about justice, it's about removing the legal obligation for the state to adhere to things like the presumption of innocence and the burden of proof required in a traditional criminal court. The source material, for instance, highlights the case of the former president labeling Antifa a major terrorist organization. And the absurdity, right, is that Antifa doesn't even have a formal structure. No leadership, no formal membership list. So this designation, it had no clear statutory legal meaning, but it was incredibly powerfully symbolic. Why? Because it established a hated other whose rights, maybe the public might agree, deserve less protection.
Okay, I agree that the lack of formal structure makes that specific designation legally weak, sure. But you seem to be arguing that the label itself creates the constitutional erosion. I'd argue, maybe, that the government's pre-existing willingness to violate rights is what enables the misuse of the label in the first place. However, we do need to address the distinction. When the state designates something as terrorism, it shifts the entire legal framework away from prosecution and towards intelligence gathering.
That's exactly it. That's precisely the slippery slope.
But wait, the state does have a legitimate need for intelligence tools when facing threats to the integrity of the state itself, doesn't it? The problem, perhaps, isn't the need to identify the threat. Maybe it's the lack of legislative clarity around what those enhanced powers actually entail. We both agree that the acts often committed by these groups are, as the material confirms, immoral, criminal, and stupid. No argument there. But if a collective organization is genuinely aiming for mass political disruption, doesn't that require identification beyond just individual acts of vandalism or assault?
It requires identification, yes, absolutely, but not at the sacrifice of due process. You mentioned the shift to intelligence gathering. That right there is the core technical threat to the Fourth Amendment. A terrorism designation effectively lowers the threshold for probable cause. See, if the state suspects a traditional crime, they generally need specific evidence of that crime to get a warrant or conduct surveillance. But a domestic terrorism designation, it allows intelligence agencies like the FBI to justify broader, much longer-term surveillance based on looser associations, ideological profiles, rather than concrete criminal action. The individual gets targeted based on who they associate with or what they might think, not necessarily what they demonstrably did.
I see the concern regarding the Fourth Amendment, but haven't the FBI and other federal agencies historically used, well, generic statutes or sometimes even just vague national security memos to conduct surveillance on politically active groups anyway, regardless of a formal terrorism designation? So is the label truly the source of the danger? Or is it maybe just the political justification for powers that intelligence agencies already assert or try to assert? I'd submit that rejecting the label entirely might leave the state without what it considers a fitting response to collective, organized ideological violence.
But the label justifies that unchecked power, certainly in the eyes of the courts and the public. You're essentially asking us to accept that because the government sometimes violates rights illegally, we should, what, voluntarily hand them a legal mechanism to violate rights legitimately? That seems like an inherently self-defeating constitutional stance. And furthermore, the Fifth and Sixth Amendments get gutted because the label often facilitates the use of secret evidence or intelligence-derived evidence that simply cannot be properly challenged in open court. This is the precise technique used internationally. Remember, drone strikes justified by secret evidence that was never disclosed? When you bring that kind of labeling power home domestically, you open the door to things like indefinite detention based purely on association, not on individual culpability.
That historical comparison to international warfare powers is sobering, I grant you. But let's ground this back in the difference between ordinary criminality and political intent. This brings us back to the redundancy argument. You argue that existing laws are sufficient. Okay, if a group sets fires and assaults officers, that's already arson and assault, fair enough. But let me propose a scenario. What if a large, coordinated group attempts to shut down all transportation and services in a state capital for, say, a week, with the explicit goal of forcing political change, a goal that goes way beyond individual criminal profit or malice? What single federal crime, in your view, fully captures that systemic threat?
Well, I'm still not convinced that existing laws are insufficient. Federal statutes already cover large-scale political disruption. You've got seditious conspiracy, which is explicitly about overthrowing or hindering the execution of U.S. law. You have felony conspiracy charges. You have RICO statutes, which allow the state to prosecute organized criminal enterprises across state lines. So why layer this emotionally charged, often vague terrorism label on top of robust statutes that already account for organized, politically motivated action? The label, it seems to me, simply shifts the focus away from individual accountability under established law towards a kind of collective guilt based on perceived intent.
Okay, that's a strong counterpoint regarding seditious conspiracy. However, even those laws primarily target the act of planning an overthrow or the commission of specific crimes in furtherance of that. The terrorism label, however vague it might be right now, attempts to define a state of being, a continuing threat that, in the government's view, justifies ongoing intelligence and maybe even preemptive action. This is perhaps the difference between prosecuting a crime that occurred and mitigating a danger that persists. Think about the January 6th events. They illustrate this perfectly, I think. Was it organized trespassing? Yes, in part. Was it simple rioting? Perhaps, for some individuals. But the political framing of it as an insurrection, that was the state's attempt to assign a label commensurate with the perceived ideological threat, the attempt to impede the transfer of power. That went beyond just prosecuting individuals for entering unauthorized spaces. They sought a label that, in their minds, justified severe punishment, not just for the specific crime committed, but for the larger political disruption attempted.
And you're confirming my deepest fear right there, that the goal of the label is simply to justify severe punishment rather than adhering to proportionate constitutional justice. This whole endeavor, frankly, is undermined by what I call the tribalism trap.
The tribalism trap. Explain that.
Yes, the fundamental risk here is that we as citizens are enabling this authoritarian expansion simply through partisan outrage. Republicans cheer when their side labels Antifa a threat, and they conveniently ignore the lack of due process protections. Then Democrats cheer when their side aggressively labels Jan 6 participants as insurrectionists and justifies collective investigation of affiliated groups. The material itself suggests both sides use this fear of the other to justify expanding authoritarian power.
Right? I agree completely that the political opportunism is the underlying perpetual problem here, not merely the definitional choice itself. That seems undeniable.
But that blind loyalty, you see, means people are actively cheering for the expansion of powers that will inevitably be inherited and likely expanded by their political enemies down the road. They're supporting the creation of these universal authoritarian tools, somehow convinced they'll only ever be used on the bad guys, their opponents. They are, in effect, supporting their own potential enslavement later on because the power becomes universal, but their side's control of it is always fleeting.
I see why you think that, and the historical record of political power consolidating across ideological shifts is terrifyingly consistent, I admit. But I come at it from maybe a slightly different angle. If we accept that real organized ideological threats do exist, and the state will inevitably seek some kind of legal framework to address them, wouldn't it be better, maybe, to focus our energy on creating statutory protections and judicial clarity around those labels, rather than pretending the need for classification just doesn't exist at all? A vague, purely political label is far more dangerous, I think, than a precise, legally defined one that has built-in due process checks. The state is going to act. Perhaps our focus should be on regulating that action effectively.
That sounds, forgive me, like an attempt to find a virtuous way to enact a vice. We already have the tools to prosecute the actions. The need you describe, this need for a systemic, preemptive response, that is precisely the definition of an intelligence operation. And historically, that's been kept separate from criminal prosecution, specifically to maintain the integrity of the Sixth Amendment right to a fair trial. By merging the two under this umbrella of domestic terrorism, we invite indefinite surveillance and the use of secret evidence directly into our criminal justice system. We are sacrificing principle for expediency, and expediency, as history shows, is the road to arbitrary rule.
Expediency is certainly a constitutional danger. I won't deny that. But I would also argue that neglecting the unique danger of ideology, of politically motivated violence aimed at systems, is also a form of negligence. We must somehow identify the structural danger, the intent to dismantle institutions, even if the individual acts look like common crimes on the surface. The failure to distinguish, say, political arson from profit-driven arson shows a kind of willful blindness to the systemic threat. And that blindness arguably can be just as destabilizing in the long run as unchecked state power.
But focusing on the intent, the ideology, that is exactly what opens the door to collective guilt and the targeting of association, which is inherently unconstitutional. Due process protects the individual regardless of how hated their beliefs might be.
I agree that due process absolutely protects the individual, but I still maintain that the state must have some ability to articulate the unique threat posed by a group that organizes solely around political violence and destabilization.
And I contend that by granting the state a special label that essentially bypasses the established constitutional framework, you are virtually guaranteeing that it will be abused, regardless of the merit of the initial threat assessment.
We are left then where we often are, in this perennial tension between security and liberty. I must reiterate my view that distinguishing coordinated political violence from common crime remains likely a necessary function of state security. However, I absolutely acknowledge the profound validity of your concern that utilizing vague classification labels seriously risks justifying severe punishment based on collective guilt and association rather than adhering strictly to individual culpability.
And I have to conclude that principles must always supersede partisan outrage. Americans seem to be sleepwalking into a constitutional trap by cheering for the erosion of Fourth, Fifth, and Sixth Amendment protections when they're applied to their perceived enemies. They're handing the government the very tools that will, eventually, almost certainly be used to target them or people they care about. The source material makes it abundantly clear, I think, the necessity of intellectual vigilance regarding state power and the serious constitutional ramifications of utilizing fear to justify these kinds of legal shortcuts.
Indeed. This debate really underscores that while ideological threats might require a robust legal response, the constitutional framework has to prioritize definitional clarity and unwavering due process. Because if the label is imprecise, the government's power risks becoming limitless. It certainly remains an unresolved question whether the necessary classification tools can ever be fully reconciled with the absolute protections enshrined in the Bill of Rights.